Megan Morris, 3 minutes now. I'm not letting you go over.
Yes, sir.
No offense, because Ms. Krasinski has been very active in this job thing for a long time, and she represents the job council. And that's why she had 5 minutes. Thank
Absolutely. And in fact, my colleague and I are planning to testify together.
you. Are you going to testify within 3 minutes?
Yes.
Thank you.
So good afternoon. My name is Megan Morris, and this is my colleague Stephanie Redfield. We're students at Georgetown Law and the Community Justice Project, and we're testifying today about the experiences of clinic students in representing clients in unemployment compensation appeals. Thank you, Mr. Chairman, for having us today.
Here's a familiar story. Julie missed work because her boyfriend hit her. Her employer fired her for not coming into work, so she files a claim with DOES for unemployment benefits. The claims examiner did not ask her if she experienced domestic violence, and they never sent her the claims determination. She finally went to the office after a month in person and was handed a denial for gross misconduct. And she thought she was ineligible to appeal because she received no additional information.
DOES is supposed to provide a safety net for hardworking people so they can recover with dignity. But the problem is that DOES is not applying the law, and there's no way of knowing how DOES operates, so there's no way to help improve the situation.
So first, for the law, DOES claims examiners ignore or don't know the distinction between simple or gross misconduct. They ask few, if any, clarifying questions in their initial facts interviews for determining whether the claimant is eligible for an exception, and they often do not mail the determinations to the claimants. This causes unnecessary appeals and delays the process further. Let me give you an example. The Office of Administrative Appeals reversed the initial disqualifying claims determination of DOES in 83% of our clinic's cases. These failures make DOES at best an irrelevant office and at worst an obstacle to justice. To remedy this, DOES should create a checklist and training manual for their employees to ensure they know what the law is, and an assessment mechanism to ensure that they are actually applying it.
Second, there's a complete lack of transparency in DOES's policies and procedures, which is a huge obstacle in addressing these problems. An example is the apparent lack of a waiver system. Despite a clear legal requirement created by this council that DOES should determine whether to waive overpayment of benefits, it is our experience that DOES has no system in place to do so. When students have represented claimants in requesting a waiver, DOES could neither process the request nor say what the waiver process was at the agency. DOES should make their policies and procedures publicly available so legal experts can comment and give advice, and they should create and implement a transparent waiver process.
Because of the problems we've just described, DOES is permeated with inefficiencies. Claimants must spend hours or days preparing for a trial that never needed to take place because DOES does not know what the law is or refuses to apply it. OAH dockets are overburdened by unnecessary appeals, while DOES wastes district resources and taxpayer dollars. DOES should use the community resources at its disposal. We live in a city full of advocates and law students, like our clinic, who would be more than happy to assist in the creation of transparent procedures and checklists as part of the corrective action plan suggested by the recent DC audit. DOES can be an efficient, transparent agency that serves district residents facing economic challenges by consistently and comprehensively applying the law passed by this council. Thank you for the opportunity to testify.
Thank you all very much, Ms. Morris, Ms. Redfield, and thank those at Georgetown Law Center who advocates this program. I welcome this kind of testimony. In fact, what I'm going to do is ask the director about it, but more importantly, I'm going to suggest that the director and my staff person, you all and others in this area, get together and talk about it and move forward on establishing clear-cut guidelines, a checklist, everything else. Because when a person is out of work, it's a very devastating thing in itself. I know when I come in the office sometime, I keep my money, the money I have in my pockets, and I rush out of the house and don't transfer it. I get into the office, I want to buy a cup of coffee, I get traumatized. I know I got good credit with my staff people. I know I got some money, even though it may be at home or in the bank. And so I can imagine what happens to a person who's out of work and to stumble through all these crazy procedures that don't work in the first way. 83% is a high number. So rest assured that this chair and this committee is going to move forthright in trying to correct these things now, because and Ms. Mallory wants to do that. We got to find a way, I think, for her to hear all these kind of complaints before it comes to these hearings, so that she can get on them before a hearing, and I think she wants to do that. So thank you all very, very much. We appreciate your service, appreciate your commitment to helping people in the District of Columbia. Thank you.